Our last speaker is lawyer Tatiana Șoldănescu. Lawyer Tatiana Șoldănescu, she's a lawyer at Livescu and Association, and she will talk about COVID-19 impact on the right to health and life of the non-COVID-19 patient from the perspective of access to medical services, a very important topic. I have to say that Tatiana, she's a young lawyer, but she's specialized in European court and in issues related to human rights in general. So we are happy to have her here as a representative of the young generation of lawyers. Tatiana, you have the floor.
Thank you so much. Please allow me to thank you first for the invitation to take part in this event and for allowing me to take the place of my colleague Monica Livescu, who unfortunately couldn't be with us today. I hope I can represent her well, and because it would have been a misfortune to not present this topic that we both think is of really huge importance nowadays. I have also prepared a PowerPoint presentation. I hope you can see it. Please allow me first to present the plan of my presentation. In the introductory part, I will try to express the necessity of this topic. And in order to understand the importance of the topic, I will briefly present statistics results to illustrate the impact that the COVID-19 had on access to medical care for non-COVID-19 patients. In the first part, I will analyze the case law of the European Court of Human Rights and the relevant international instruments. For the second part, we have prepared a case study on the Romanian legislation during the COVID-19 pandemic and its compliance with health protection standards. And last but not least, we will have some concluding remarks. So let's start with the first part. As you can see on the screen, we have tried to identify three parameters that should define the governance norms. And that would be legitimacy, transparency, and accountability. We believe that all the restrictive measures should respect these parameters. The legitimacy would mean that each restrictive measure should be convincing on their necessity, and it should have ongoing assessment in order for everyone to understand why that particular restrictive measure is necessary. The second parameter identified was transparency. That would mean everyone should know from the public authorities why such a measure would be necessary, what are the protective measures for that restrictive measures, and in what way it is performed, and what are the remedies against this restriction. And last but not least, a very important parameter would be accountability. Each restrictive measure should have the opportunity to be challenged by everyone who is affected by that measure. Moving on, as I have stated in the introduction, and as Judge Motok started this debate, I'm going to present some numbers that would justify the necessity to treat this subject. So we have read a lot of studies and statistics that were made. You can see on the screen just some of the most important results of these studies. And I'm pretty sure that you can see the numbers, the high numbers that resulted from these studies. These high numbers suggest how much the COVID-19 pandemic has affected patients, people who didn't suffer from COVID-19, but have other health problems that require medical attention. For example, 53% of the participating countries in one of these surveys said that there was a disruption in medical services for the treatment of hypertension. 80% of doctors reported that the mental health of their patients worsened during the COVID-19 pandemic. So it is clear that these statistics confirm the importance of the analysis of the effects of limiting the access to medical services for the chronically ill during the pandemic. And it also shows that the authorities might have neglected non-COVID-19 patients from the desire to limit the spread of COVID-19. Moving on to the first main part of this presentation, we are going to analyze a little bit the case law of the European Court of Human Rights on the right to health. We all know that the convention itself does not expressly guarantee this right per se, but of course it is a right that derives from other rights that we are also going to analyze further. The case law of the European Court on the right to health refers quite frequently to other international instruments that help the court to decide in a way or another. These international instruments, as you can see on the screen, are the recommendations of the Committee of Ministers in the field of health, the Convention for the Protection of Individuals with regard to automatic processing of personal data, the European Social Charter on Health. But also, it is important to know that when an individual complains on his breach or violation of the right to health, he usually argues on Article 2, 3, 8, 13, and 14 of the Convention, and why not Protocol 12. For the purposes of this presentation, we are not gonna try to talk about all of them because that would exceed the time. So we are going to analyze the Article 2, which guarantees the right to life. As you can see on the screen, when analyzing a complaint based on Article 2, the court will verify the two limbs of this article, which are the substantive and the procedural one, and will also analyze if the state has fulfilled its negative and positive obligations that were established in the case law of the court, for example, in the case Lopez de Sousa Fernandes versus Portugal, or Calvelli and Chilio versus Italy. Just to name these obligations, the negative obligation of a state would be that that state must not interfere with a person's health unless there is a justification in compliance with the convention. So the state has to refrain from actions or omissions that would endanger life or put the health of people in serious danger. The positive obligations of the state are both of substantive and procedural nature. The substantive obligations would mean that the state should take measures to protect the health of people, enact regulations requiring hospitals to take appropriate measures to protect the lives of their patients, including to exercise control over the implementation of measures. The procedural obligation would mean that the state must establish an effective, independent judicial system so that the cause of patients' deaths would be properly analyzed. Moving on to the analysis of the Article 2 in the case of the court, it was interesting to find out that the court has accepted that state liability can be engaged based on the substantive aspect of Article 2, in particular where, for example, the life of a particular patient is endangered by depriving him of access to life-saving emergency treatment, and where a systemic or structural dysfunction in hospital services leads to a patient being deprived of access to life-saving emergency treatment, and also the authorities are aware that they should have applied that medical treatment but failed to do so. So in order for a case to fall into the category of those who involve both medical negligence and those in which the patient is deprived of access to emergency treatment, in the case law of the European Court, we have found out that certain factors are to be met, and they are also listed on the screen. I'm only gonna briefly go through them. The acts and omissions of the healthcare providers must overcome a simple medical error or negligence. So the deprivation of the patient of the emergency medical treatment must be done even, well, especially when it is known that the person's life is at risk. The dysfunction in question must be objectively and realistically categorized as systemic and structural. There must be a link between the dysfunction referred to and the damage suffered by the patient. And last but not least, the dysfunction in question must have resulted from the state's failure to fulfill its obligations to provide a regulatory framework in the broad sense mentioned above. On the next slide, we have selected some judgments against Romania that are of particular interest because we have identified some general principles that we actually recommend the public authorities to keep in mind when taking measures that might lead to limitations to the right to health of people that are not COVID patients. So in the first case selected, we have identified the following general principles. You can see on the screen the exact paragraphs, but I have extracted the principles so it is easier for the people who are watching us to understand. The following principles would be that the acts and omissions of the authorities in the field of healthcare policy may, in certain circumstances, engage responsibility under Article 2. We shouldn't forget the principle of practical and effective rights. So the right to health should be practical and effective and not just theoretical and illusory. The authorities should do everything that is expected of them related to medical treatment. The state's obligations regarding appropriate health care is one of means and not result. I think this is a very important distinction to be made, that the state has an obligation of means and not of result. In the following cases, some other principles we have identified some other principles that, for example, in the first case that you can see on the slide, the court established that states have an obligation to provide prisoners with medical care. In the next case, the court actually said something really interesting, that the state has to take appropriate measures, especially when the capacity of patients to take care of themselves is limited, and that the court has to assess if the state had done all that was necessary to prevent the applicant's life from being put at risk by providing him or her with adequate medical care in a timely manner. In the last case that we have selected, which is you can see a long extract from it. The following principles have been identified, that that Article 2 of the Convention may come into play even though the person whose right to life was allegedly breached did not die, which means that Article 2 guarantees the right to health. The denial of health care to the general population may fall under the second article of the Convention. And even if the state has failed to apply one particular measure provided by the domestic law, it may still fulfill its positive obligation by other means, by applying, for example, other medical treatment. This would be the part referring to the case law of the court. As I've said in the introductory part, I'm also going briefly into the relevant international instruments that also the court, when deciding on its cases, takes into account. And we have, for example, the International Covenant on Economic, Social and Cultural Rights. We have Article 12 from this international instrument, which was explained in the concluding observations of the Committee on Economic, Social and Cultural Rights. to imply the obligation of states to make available healthcare units, goods and services in sufficient quantity and accessible to all, both physically, economically, and without discrimination. We have also the International Covenant on Civil and Political Rights. We have Article 6 from this international instrument, which also states the right to health. But even more than this, we also have Article 26 from this international instrument that guarantees the right to equality and not to be subject to discrimination, which we believe that it is crucial for the exercise of the right to health. We believe that health facilities, goods and services must be accessible to all, which maybe during the pandemic and even now wasn't the case. Maybe only the COVID-19 patients had access when they wanted to medical care, and other patients suffering from other diseases couldn't benefit from health care. So, and last but not least, we have also the European Convention for the Protection of Human Rights and Human Dignity against the Application of Biology and Medicine, also known as the Oviedo Convention. And briefly, I'm gonna go through the non-binding international instruments that also set guidelines that the public authorities should keep in mind when taking uh, health related decisions. We have the European Charter of Patients' Rights. We have the Syracuse Principles, the Lisbon Declaration on the Rights of Patients, and the Declaration on Patient-Centered Healthcare enacted by the International Alliance of Patient Organizations. All of them provide the right to health, and they describe this right in certain manners. It is important to emphasize at this point that we believe that patients' rights may have been subject to restrictions when imperative requirements of general interest demand so, but only if they comply with the principles of necessity, proportionality, and adequacy to achieve that objective, and when these measures are applied without discrimination. And for the last part of this presentation, we are going to analyze the case of Romanian legislation during the COVID-19 pandemic and its compliance with health protection standards. You can see on the screen the most important norms in the Romanian legislation that provide for the right to health. And for the second part of this case analysis, we are going to analyze the administrative decisions and the norms that were taken during the pandemic. We have identified 16 orders of the Minister of Health that were issued related to the pandemic, and that actually limited the access of non-COVID-19 patients to hospitals. So we believe that the principles resulting from the court's case law that we have cited before should and could have been applied in analyzing the situations in which people with other chronic diseases were deprived of access to medical service during the time when these orders of the Minister of Health were in force. For example, we have had in this during this pandemic certain administrative decisions, for example, stating that
Tatiana, sorry, you should conclude because we are almost.
You can see them on the screen. They are very detailed. The measures are very detailed. So I'm just going to conclude with these conclusions. We believe that the enactment of any normative act during the pandemic in Romania triggered by the COVID-19 crisis should have taken into account the landmarks expressed before, in order to avoid the violation of fundamental rights such as the right to life and non-discrimination for all patients, and that all the public authorities should have kept in mind the preamble of the Universal Declaration of Human Rights, to which this conference is dedicated, and which very important phrases from the preamble are shown on the screen, and that these guidelines should have been kept in mind, and maybe will be kept in mind by the authorities in the future, to avoid any other limitations to the right to health of people that didn't suffer from COVID-19. Thank you so much for your attention, and I would also like to congratulate all the speakers before me for all the knowledge that they passed on, and for very interesting presentations.
Thank you very much, Tatiana. It was really fascinating presentation because of the topic, but also because you put together non-binding instrument, binding instrument, and also Romanian legislation in this respect, and of course the convention. I think it is an issue. It will be more and more an issue at the domestic level, and at a certain moment at the level of the court. Indeed, you have mentioned that today we celebrate the United Nations General Assembly adoption and proclamation on the 10th September 1948 of the Universal Declaration of Human Rights. It's an extremely important day all over the world. So it was important also for us in Romania to have this webinar, even if it was a very long one. But I think it was fruitful and rewarding for those who had the patience to listen to us. And I thank very much all the speakers that some of them they have to leave, for their excellent presentation, very rich, very complex. It was a fantastic discussion, and also to the participant and indeed to our media partner, Juridice. Have a wonderful day, all of you. Bye-bye.